appearing in the Queen on the application of Shindler and another against Chancellor of the Duchy of Lancaster.
Yes, Mr. Rooney.
My Lady, my Lords, I appear on behalf of the appellants with Leonard Jr. Brown and Ms. Davis. The respondents are represented by Mr. Eadie, Mr. Coppell and Mr. Cross. First of all, may I thank the Court for arranging matters to hear this matter so urgently.
Well, we understand how urgent it is.
Indeed. I have to apologise. There is a memory stick, however.
Worry not, worry not.
So I'm afraid we're limited to hard copies.
We may find ourselves in some difficulty, but we'll do our best.
Obliged, my lady. As I understand it, we have the court expects us to finish at 1 o'clock.
We do.
And having discussed it with my learned friends, I've suggested a division of time whereby I'll speak for 80 minutes. He'll get 80 minutes, and I'll have 20 minutes to reply. Those are maximum times, of course.
They say he'll get 80 minutes if we ask him to reply.
Absolutely, yes. I'm being presumptuous as usual. This comes before the court clearly in terms of the court considering an application for permission. And as I understand it, if permission is granted, then the substantive argument follows thereupon immediately. It is a matter of urgency, as I've mentioned, because it is 30 days until the referendum. And it is 2 weeks from today, which is the last day in which individuals can register to vote online for the referendum. This case, however, may be said to be the culmination of a long campaign by, in particular, the first appellant, Mr. Harry Shindler, while the second appellant, Ms. McLennan, has come over from Brussels, since it's only 2 hours on the train, hardly an expat. Mr. Shindler is not here, 95, he's a bit too frail to make it over. I think he is, however, going to be watching online.
There are some benefits around your arrangements. Very glad that Mr. Shindler is able to watch.
Obliged, my lady, because it is very much something which has been very close to his heart, and which he has sought to have the law changed for quite some time. As I say, it is somewhat ironic, of course, that Mr. Shindler is at the age which he is, unable to come to this, the culminating matter in this long campaign. Because, of course, if he were less, as it were, more mobile, then theoretically, according to the respondents, he could always just come back and take up residence again in the United Kingdom within the next 2 weeks and get a vote in the referendum. Because, of course, the effect of this provision is not to deprive long-term free movers, as I will refer to the two appellants, of the right to vote, but to suspend it pending the period in which they have exercised their free movement rights for too long, for more than 15 years.
What would taking up residence involve? How long would he have to come back for?
That is beyond my immediate knowledge. All I know is that when this matter came before the Divisional Court, it was said that it was possible for people seeking to vote to establish dual residence.
But you have to be resident on the qualifying date, don't you?
Yes.
Which I believe is the 10th of October or something like that.
Well,
this one, it's the 8th of June, isn't it?
The 8th of June is the last day in which you can register.
That's the last day you can register, so
I thought
it doesn't matter when you're resident.
Yes, I mean, I'd rather assumed that if you were resident in the United Kingdom on the 8th of June, you could then register online.
Yes, you can register online up till the 8th of June, and you would then register whichever address you had that fell within a constituency either in the UK or in Gibraltar. But that, of course, involves not simply coming over on holiday, but establishing some form of residence. Although certain individuals on relatively short-term visas, 1 or 2 years, who are on, as it were, working holiday, Commonwealth citizens who are resident in the UK, as at the 8th of June, will have the right to vote, and many have indeed registered. But as I say, the issue is then that one could get the right to vote, give up, stop the suspension thereof, if the current exercise of free movement was curtailed or modified in some way. I.e., what that means is that the rule penalises the appellants for having exercised the free movement for more than 15 years. It provides an incentive for them to modify or give up on that free movement by coming back to the 8th of June to the United Kingdom or Gibraltar in order to get the vote back. And in so doing, both penalising and as it were, offering an incentive to come back, it is deterring them from continuing to exercise their free movement rights. Now, I see that that is more than sufficient to bring into question the issue as to the justification as a matter of EU law for this provision, this suspension of voting rights. I say that is enough for it to be incumbent upon the respondents to show justification of this measure as a matter of EU law. The respondents say, oh no, it doesn't. It doesn't because, and we will be going into this, it doesn't need to be justified because, well, it isn't really deterring free movement. It's not really imposing a disadvantage. And even if people say it was, that's to be discounted. So the general approach which the respondents are taking in this is to try and persuade the court, as they persuaded the Court of Appeal below, not to engage in any kind of proportionality assessment of this suspension of the vote, whether at common law or as a matter of EU law. And I say to this court, beware of the siren song, that the arguments which are put forward, and we will come and look at these more, the arguments that were put forward and were successful before the Court of Appeal for this court not to consider proportionality were two arguments based on EU law. One of them as to the meaning and intent and effect of Article 50 of the Treaty on European Union. And the respondents, and we'll look at this in a bit more detail, put forward a wholly novel interpretation of this provision for which they admit there is nothing to support in the travaux préparatoires, and which involves a reading of Article 50 of the Treaty on European Union, dissociating it from the rest of its context within other articles of the Treaty on European Union and other articles in the Treaty on the Functioning of the European Union. So it's putting forward a novel interpretation of EU law, what Article 50 really means. But it's putting, if and insofar as I understand that they are putting it forward to this court as the correct interpretation of EU law, this court, of course, is a court of last instance. And therefore, there is an obligation under Article 267, subsection 3 on the court to make a reference on points of law, of European law, interpretation of the treaties, which have not previously been the subject of interpretation by the Court of Justice. Make a preliminary reference on the point to the Court of Justice. Now, clearly,
but you're not suggesting that we should do that.
I am absolutely not, because there just is no time for that. But it doesn't take away from that is what the obligation is, if and insofar as this court listens to the siren song from the other side and decides this case in terms of Article 50 as a way of avoiding a proportionality challenge, of a way of avoiding the examination and decision upon a proportionality challenge. Because the one thing that we do know is that the test under EU law for what a proportionality challenge is Act Clare. There is absolutely no need for this court to make a reference to the Court of Justice as to what would be required in assessing a proportionality challenge. There's already been a very full discussion of proportionality in EU law in the case of Lumsden and Lord Reid's judgment, Lord Toulson.
What is the novel, or perhaps putting it the other way around, what is the traditional or conventional view of Article 50, subsection 1, in relation to which you say that the government is now putting forward a wholly novel alternative?
I say it's a phrase which is used throughout the treaties, and I will be coming on to develop this. It's a phrase which is used throughout the treaties in accordance with one's own constitutional requirements, and all it means, in terms of a plain language, is that there is not a uniform procedure mandated as a matter of EU law. The matter is, as it were, sent renvoi back to the member states to determine matters on the basis of their constitutional requirements. But that does not mean, because the novelty of the respondents' approach is to say that EU law, Article 50, means there is a carve-out, that's the phrase they use, a carve-out from those national constitutional requirements to mean that issues of EU law, which would otherwise arise, are to be disregarded. So they're saying that Article 50 is telling member states how to interpret and understand their own constitutions. And I say, that's novel. That's, you would think something as new as that might have some kind of backup in terms of the discussions and the travaux préparatoires. You would think that given it is a phrase which is commonly used throughout the treaties and has been for the past 50 years, that there might be some discussion in the doctrine or in the jurisprudence of the Court of Justice, but there is nothing. That's the novelty. And that's what the siren song is. And one wonders why it is that this argument is being pressed. And the only reason can be is that because the respondents are wary of and are unwilling to have this measure, it's assessed by the court for its proportionality. So, if this court were to follow the respondents' suggestions and decide on the basis of Article 50 on their interpretation, such that to find that there is no need to go and examine and decide on proportionality, that would be deciding a point of EU law which is not Act Clare, which this court has a duty obligation under Article 267(3) to refer to the Court of Justice, but which, of course, we all know it cannot be done. Rather than get into those deep waters of ultimately resulting in a questioning of the legitimacy of a decision by this court on Article 50 as a court of last instance, when that is an issue which is ultimately under our current constitutional arrangements, by which I include the notion of EU law, a matter for the Court of Justice, not for this court.
We say it can't be done, it would have to be done.
No,
I mean, if there's a relevant doubt, we have an obligation to refer.
It wouldn't have to be done in terms of the way that the Court of Appeal did it, which is to say that this means that there is no basis on which a proportionality challenge has even to be looked at.
No, of course. I meant if you're right that that is questionable, arguably questionable, then you aren't necessarily right in saying that the opposite is clear, and therefore there would be, on that basis, a referable question.
There would be a referable question.
Isn't there a problem about this, in that the Article 267 refers to cases where it's necessary to get a decision of the European Court of Justice? If it's impossible to get one at a time when it's going to make any difference it can hardly be said to be necessary.
Well, it's necessary for the resolution of the question before the National Court. The idea that it's impossible is simply because everyone involved in this case and the court, is not that it's impossible as a matter of law, but that it is undesirable that the referendum date be disrupted. So there is no impossibility. There is clearly a possibility and there remains an obligation, but it is not one which I am asking this court to engage because, and it can do that compatibly with EU law, by deciding the case on proportionality, because we know what proportionality requires. And the same goes for the way in which they argued before the Court of Appeal and the Court of Appeal accepted on the impact on free movement rights, where they, again, a particular interpretation of EU law was proffered by this and accepted by the Court of Appeal, but there are contrary Grand Chamber recent decisions from the Court of Justice which do not conform to that interpretation. I speak specifically of the case of De Cooper, 2006, which we'll come on to, and of course the more recent case of Martins. So again, in any normal circumstances, as a court of last instance, this would be a matter for reference to the Court of Justice. Again, to avoid this, but again, that argument is being put forward simply as another way of persuading the court not to undertake proportionality analysis. What are they so afraid of?
Well, they'll tell us, perhaps.
Maybe they will, maybe they won't. I haven't heard yet, because we're given a robust proportionality defence. At least we have been to date. But I say it's not one which actually is founded on any of the relevant evidence and materials which were before Parliament at the time. But anyway, that's where I'm coming from. As I say, I repeat, beware the siren song, which the Court of Appeal didn't beware and fell on those rocks of deciding on on points of EU law of dubious. Well, I say they were wrong, frankly. Okay, they got it wrong on the EU law, but that's fine. They're not the court of final instance. This court has to, on new points of EU law or disputed points of EU law, which are not Act Clare, as neither of these are, to make a reference. We don't have time for that. Decide on proportionality, and that avoids all the issue.
I suppose you could say it's ironic that the government is arguing that EU law is inapplicable to this particular debate, relying on 2 points of EU law.
You could say that, my lady. I couldn't possibly.
You couldn't possibly comment.
And presumably you'll also deal at some point with Lord Justice Elias's analysis that Parliament didn't intend the 2015 Act to be controlled by the 1972 Act.
Well, that was an analysis which Lord Justice Elias put forward. It wasn't adopted, at least at the time when it was put forward by the respondents, because it was.
But it's a decision of the majority. I mean, it was agreed with by Lady Justice King.
Yes. And I say that again is constitution making on the hoof, frankly. It's contrary to such constitutional principles as we do have, which are that constitutional statutes, I think, and we're all agreed insofar as there is a constitutional statute. The European Communities Act 1972 is one. We seem to be told that in HS2, among other decisions. Constitutional statutes are not subject to the normal rules of implied repeal or of, indeed, implied modification by other principles. So one could say, of course, if you want to hold on to and uphold the notion of the sovereignty of Parliament consistent with our constitutional principles, such as the principle of legality and consistently with the idea of constitutional statutes, the European Union Referendum Act 2015 could have said in terms that this referendum will not be subject to any form of challenge based on EU law, and the European Communities Act 1972 will be disapplied expressly if and insofar as it requires otherwise.
The 2015 Act, though, is an act of coordinate significance, isn't it? Isn't it another constitutional statute? So the point you made may not necessarily apply.
Well, it will still apply because we're dealing with individual rights. The principle of legality applies to the notion of acquired rights. Again, one would assume that insofar as those principles bite, what is being said here is that by implication, although Parliament might have made it express, it decided not to in this case because everyone knew, did they? Everyone assumed that the rights which people might have had under EU law could not be paid in aid in this case. Where does that come from? Is there anywhere in the materials before Parliament to suggest that that was their intention or understanding? And what is it about this statute that makes it a constitutional statute? It's a particular statute which allows for a referendum. It does not change the Constitution in any sense at all. All it does is, as other referendums have been allowed, is for referendums to be held in the United Kingdom and for Parliament, if so advised, to follow or not to follow what the result is. If we think otherwise, we're suggesting that the sovereignty of Parliament has somehow been compromised by the referendum. So one can't have it both ways. If you're holding on to the sovereignty of Parliament and the principle of legality and the principle of respect for acquired rights, then yes, one can have the idea that by express provision, Parliament can have said EU law rights cannot be used to challenge this Act. But it did not do so. So therefore the Act is in the same category as any other Act, as the Merchant Shipping Act, which was challenged in factor 10. So that's why I say Lord Justice Elias's analysis, which was his own, is not one which actually, when one looks at the case law, and it wasn't argued before him, it was something which was came from his own suggestion, and was not something which either side actually agreed with or were able to argue upon in terms of the authorities. But we do have some of the authorities here which would say that that is not a tenable position.
Just tell me where the Act is. Perhaps you can't in these bundles. I'm just
the 2015 Act?
Yes. Does it have a...
It's tab 7 of volume 1. As I say, this is a case about individual rights, and perhaps unusually among such recent voting rights cases as have come before this court, it does not have the whiff of the prison cell about it. There is no suggestion that the appellants in this case have done anything wrong which would justify their deprivation of the right to vote. Now, it has to be said, I think, and it's probably my fault anyway, since I brought the cases here, that the previous prisoners' rights cases have somewhat, perhaps, given the neuralgic sensitivity of prisoners voting as a political issue in the United Kingdom, perhaps not emboldened this court to be as strong as it might be when it comes to issues of the fundamental nature of the right to vote within a democracy, which this country is. In this case, I say we start off from a premise that as citizens, the two appellants in this case have a right to vote. That, in fact, is really what the Act is also premised upon, given that it allows for the possibility of that right being regained. from its suspension should one return to the United.
On what basis do you say that citizenship as the test for the franchise should be regarded as the norm? I mean, historically, there have been a number of different models. Citizenship, for instance, is the American model. Ours has historically generally been based on residence.
It's historically generally been based on sex as well. But if one wants to do the...
Yes.
And property, absolutely. In fact, on that, I think it'd be worth looking at the case of Nairn, which is
Oh, I think we...
volume 3.
I don't think I ever expected to be referred to the case of Nairn. How wonderful.
Well, lady, I'm doing it just for that. But it is actually relevant, strangely enough.
Volume 3, what?
62.
Women are not persons.
Yes, that's right.
62, this is the case, the well-known case from 1908, when it was decided that women were not persons for the purposes of the possibility of exercising the franchise for Parliament, on the basis that Parliament could not have intended something so ludicrous as suggesting that women might be able to exercise the right to vote. The case is an interesting one on many levels. One perhaps the most interesting, it was argued by the women themselves, of course, who would not have been able to go to the bar, and therefore were, as the Scots would say, party litigants in person. They had some assistance before the House of Lords from a junior Scottish advocate, but as it turns out, the other side weren't called upon, so perhaps it's not such a great precedent for me. But the point one wishes to make from it is precisely this notion of history and the underlying common law. If one looks at the decision of Lord Loreburn, Lord Chancellor, page 160 in particular. But he notes as follows: students of history know that at various periods members of the House of Commons were summoned in very irregular ways, and it's quite possible that just as great men in a locality were required to nominate members, so also women in like position may have been called upon to do the same, or other anomalies may have been overlooked in a confused time. I say it may be so, though it has not been established. A few equivocal cases were referred to. I was surprised how few. And it is the same in regard to judicial precedents. 2 passages may be found in which judges are saying that women may vote at parliamentary elections. These are dicta derived from an ancient manuscript of no weight. Old authorities are almost silent on the subject, except that Lord Coke at one place incidentally alludes to women as being under a disqualification, not dwelling upon it as a thing disputable, but alluding to it for the purposes of illustration as a matter of certainty. This disability of women has been taken for granted. It is incomprehensible to me that anyone acquainted with our laws or the methods by which they are ascertained can think, if indeed anyone does think, there is room for argument on the point. It is notorious that this right of voting has in fact been confined to men. Not only has it been the constant tradition alike of 3 kingdoms, but it's been the constant practice of ours knowledge of what has happened from the earliest day to this. And it goes on, only the clearest proof of a different state of things prevailed in ancient times could be entertained by a court of law. In probing origin of so inveterated usage, I need not remind your lordships that numberless rights rest upon a similar basis. Indeed, the whole body of the common law has no other foundation. So, the whole body of the common law, as at 1908, rested on the indisputable, notorious, well-known, non-arguable with the fact that women were not equal to men and were not entitled to equal rights, most certainly not in the public sphere. 100 years later in AXA, my Lord Mance says that the common law rests on the foundation of equal treatment for all. The common law has moved on, it would seem, in the 100 years between Lord Lorburn's comments and the decision in AXA, and rightly so. But if that is the case, if the common law has moved on such that women are regarded as entitled to the right to vote, then I say the common law is strong enough in its notion of equal rights in relation to the right to vote to apply even in this case. Let me propose a counterfactual. Taking something topical, for example, the exclusion of women from private golf clubs. What if, in response to votes from certain institutions, Parliament decided this was something worth looking at? In fact, Parliament decided that it was worth having a referendum on because it was rather controversial and there were competing arguments on both sides, but far better to put it to the people as to whether or not the Equality Act 2010 should be amended so as to apply to private clubs such that they were no longer entitled to exercise discrimination on grounds of sex in relation to their membership. Now, let's say that, given that there are strongly competing views on which way to vote within the governing party which was proposing the referendum, they say, well, tell you what, we will put it to a referendum, but just let men vote in it, because there's no point in allowing women to vote, because we know how they're going to vote. They're parti pris. And that would make people question the legitimacy of the referendum and the result, and we don't want that. So what we'll do is, we'll use the existing referendum, but we'll just cut out anybody who identifies as women. I don't know what they do about trans, but as women, because women are the ones, because I'm not sure Moorfield has a policy on trans people, but women are the ones.
About the Scottish Parliament or the UK Parliament?
I'm talking about the UK Parliament because this is the Equality Act and it's a reserved matter. So the Scottish Parliament couldn't do this. And if they did it, there would be a judicial review for trying to put a referendum on something which didn't have competence. So it's a UK Parliament point. What would this court then do when faced with a challenge that then followed from women saying, just a minute, this referendum has been fixed. Why are you not giving us the right to vote? And no doubt the respondents would say, well, it's what Parliament wanted. Parliament is sovereign, and there are good reasons for this. We don't want people questioning the legitimacy of this referendum because we all know how women are going to vote. So far better if we just slightly modify the existing franchise by cutting out the women. And then when there is a referendum decision in favour of amending the Equality Act, then nobody can complain because at least we know it was just the men that said so. Now, there in a nutshell is the argument which is put forward for the exclusion of the appellants in this case from this referendum. That and nothing more. It is not anything to do with the idea that these people have cut off their links or are no longer properly part of the polity of the United Kingdom in exercising their free movement rights. That is not something which ever came before Parliament in terms of its explanation as to why this referendum franchise was being chosen and these appellants were being cut out from it. No. What was said is what the appellants now at last, the respondents rather, at last say in their case for the first time before this court, which was not said in the courts below. And I refer this court to the respondent's case at paragraph 66, sub-paragraph 6, page 31.
Sorry, where is it?
It's the respondent's case.
Respondent's case.
Paragraph 66.
Right.
Sub-paragraph 6, did you say?
Sub-paragraph 6.
Yes. A desire not to undermine the legitimacy of the referendum by being seen to reform the franchise.
with the objective of influencing the outcome. Oh, strangely, is that...
I had marked that passage.
I'm sorry, my lord?
I had marked that passage.
Well, so did I. So it's nice to see we are on the same page, at least literally. So, yes, that's why we have this referendum. That's why this franchise exists. Not because of all this claims about, oh, well, we're just checking to see how committed they are to Britain and Britishness. It's not that. It's because of some political compromise. Internal political compromise among those within the governing party who favour one side in the referendum as opposed to the other. Now, given that is the reason which the respondents, the government now admit, is the basis on which the referendum franchise has been chosen, the question is that a legitimate reason, such as can justify, on any normal analysis, the removal of the right to vote, which is, in this country, post-Nuremberg, associated with citizenship, among other things.
The very sort of use of records of parliamentary proceedings which was deprecated by the House of Lords in Wilson and County Bank.
And indeed, the records of parliamentary proceedings were put in by the respondents, not by me.
Doesn't matter who put them in, on the face of it, it's not a legitimate use of them.
Well, the respondents are the government, and they have set out in their own words, I haven't forced them to, as to what they say the purpose was, the reasons for this referendum franchise. And in any event, given that we are dealing here with matters arguably in terms of EU law impact on free movement rights, there is certainly case law, most notably, most recently, the Scotch whisky case, which says that the courts look at the reasons for the passing of the measure to establish its objective. That's what the objective of this is. And it would be willful blindness to say otherwise, because that's what the respondents say it is. And they're right. They're right because, strangely, that is precisely what government spokesmen in Parliament have said when asked as to why they would not change this referendum. Because one of the great issues in this case is what doesn't make sense is that the government has repeatedly described the 15-year disenfranchisement as arbitrary, as having no justification. They've said it in letters to the first appellant. Personally, if you look at page C20 in the bundle rather than the authorities, so a letter from the Prime Minister to the first appellant, dated the 28th of January, in which he notes that if we win the general election, we will abolish the 15-year rule that prevents millions of British expats from being able to vote. If our party wins power in May, we will remove the cap to prevent them voting after being out of the country and allow them to vote for life. Then, if you look at C26, a letter from the government minister responsible for these matters, John Penrose. Second paragraph, is sympathetic to constituents' concerns regarding the 15-year rule. As your constituents say, existing legislation means British citizens resident overseas lose their voting rights after 15 years. I'm happy to confirm that the government doesn't intend to remove this arbitrary time limit. Going over the page to C27. Another letter from 10 Downing Street, dated the 13th of July 2015, again to the first appellant, noting in the second paragraph, as confirmed in the Queen's speech of 27th May, the government's committed to removing the 15-year limit on parliamentary voting rights for British citizens living overseas. Like you, the government believes that the current 15-year limit is arbitrary. And if British citizens want to vote in UK parliamentary elections, then they should be able to do so. Now, that's not using parliamentary material illicitly, although that clearly is a briefing. This notion of the word arbitrary is one which is used not only in these letters, which are public documents, but also in various statements by government ministers when asked about votes for life. So one doesn't have to get worried constitutionally about looking at Hansard when we have outside evidence in any event to show the government's repeated, stated, considered position is that there is no justification for this measure. But here they come. They come to this court, the government, and they say, oh, it turns out, although they said that was politician talk. That was using the word arbitrary in a political rather than a legal sense. And when they say arbitrary, they didn't really mean it. And we can now come, as the government, to the court and say, yeah, it's not arbitrary, it's actually got a really good legitimate aim, which is not actually spoken to anywhere in Parliament or elsewhere, but it was one that passed muster before the European Court of Human Rights in Shindler against the UK and before the Court of Appeal in Preston. And we don't need any evidence to show that that really was the legitimate aim of what Parliament was intending, because it's enough for us to assert it. But I'm sorry, you can't do that. Surely there is a responsibility on the part of government, not just not to say one thing and do another, but to say the same thing before different public fora. The other issue about the government's failures in consistency in approach is also evidenced by their recent submissions before the European Court of Human Rights in the application of Mr. Muhan to the Strasbourg Court. Those observations are from the 6th of May and are to be found at D180 of the bundle. They start at D179. And the tenor of those observations, we don't have to go through them in any great detail, is that Article 3, Protocol 1 of the European Convention on Human Rights has no application to referendums. Therefore, all the decisions of the Strasbourg Court, which refer to rights to vote and checking its proportionality, don't apply when it comes to referendums. And if we see, in particular, don't apply when it comes to referendums about the European Union. If we look in particular at page D191, paragraph 37, in any event, say the respondents to the European Court of Human Rights a couple of weeks ago, the referendum is not in any sense the equivalent of an election to a legislature and does not merit different treatment. The line of cases in which the Convention organs has found referendums to fall outside the ambit of A3P1 include referendums which could have a direct and material effect upon the powers and operation of the legislature of the respondent state. That is so in the case of referendums on accession to the European Union, which entail that the European Parliament is introduced as a new legislature and the powers of the national legislature are constrained. It's also in case of the referendum on the alternative voting system. The importance of a referendum is a theme which is repeated by the appellant. However, there's no doubting the importance of the question, but votes on accession are also matters of considerable and historic importance. And importance for democratic decision is not the criterion for inclusion in A3P1. So, the constant theme is, as I say, that the A3P1 is of absolutely no relevance when it comes to looking at referenda, because in no sense is a referendum the equivalent of an election to the legislature. That's what they say to the European Court of Human Rights. But they say the opposite to the courts here. They say, in every sense, is the Strasbourg legislation, which is only about referenda, to be applied in the case, which is only about elections to national legislatures, to be applied in the case of this referendum. So before the Divisional Court and before the Court of Appeal, we were taken on a tour d'horizon of cases from the European Court of Human Rights showing how residence requirements for national elections to national legislatures have been held to be justified. And it's been said, and the same can be said for referenda. So all I'm asking for is a bit of consistency, in fact. Is it too much to ask?
But isn't that an admissible argument? I mean, even if the referenda are not within A3P1, nonetheless, the underlying theme of the significance of residence may be a common theme.
Not if one actually then looks at the criterion by which the issue of the referendum, the legitimacy of residency was upheld by the court. If you look at the actual reasons, and I've quoted some of those, the Melnichenko case against the Ukraine in particular. Find that, where have I quoted that?
36, volume 2, 36.
And that's at volume 2, 36, if I have a quick look at that. I've quoted that in the case. Right, in the case, it's in the case.
Where have you quoted this in your case? Just give us the reference. Well, paragraph 55, I suppose, perhaps.
I mean, I've certainly quoted it in the case, but...
Well, you've referred to Melnichenko in paragraph 55 of your case. No, sorry. No, that's wrong. That's sorry. Sorry.
Well,
That's the respondents, yes.
yeah.
5.37, I think, is your case. Yes.
Yes, apologies. So, those are the criteria set out which apply to the national legislature, and it's from paragraph 56 of Melnichenko. A residence requirement for voting may be justified on the grounds of the assumption that a non-resident citizen is less directly or continuously concerned with or has less knowledge of a country's day-to-day problems. You can see that this is all about elections to the legislature, which will have, no doubt, a particular broad mandate and manifesto from various competing parties over a broad range of issues. But this is not an election about a party's manifesto. This is a referendum about one question only, one issue only. Should the UK remain or leave the European Union? And as I said, from the point of view of focusing on individual rights, that question can be understood as, should British citizens retain or lose the status of EU citizenship? That's simply the individualisation of that same question. So, when it comes to asking, well, can one assume that on the basis of the question, should British citizens remain or lose EU citizenship, that the appellants and others like them, who are British citizens exercising those free movement rights, will be less directly or continuously concerned with that question? I think not. Would they have less knowledge of it? I very much doubt that, precisely because they are relying upon their British citizenship every day of their lives, because it's their British citizenship and Britain being a member of the EU, which gives them rights as EU citizens against other member states.
Just give us, and you've made this point powerfully, that if anyone is concerned, it's they who are concerned by loss of European citizenship in paragraph 4.16 of your case. But
yes.
just give us the references to the treaty articles which guarantee these rights, attaching them to European citizenship.
The particular rights are set out in Article 20 of the Treaty on the Function of the European Union.
Yes.
And that...
Article 20, paragraph 2, right
yes.
to move and reside freely within the territory of the member states.
But there's a whole host of rights associated with that.
Well, and presumably rights to... yes.
There's also the fundamental right, I think, under Article 18, not to be discriminated against on grounds of nationality.
Yes.
Have you got, sorry. Article 20.
There's quite an interesting paragraph in the second applicant's witness statement about what she would lose if she lost her EU citizenship. Set of paragraphs.
And that's at...
This is in tab B.
Tab B5.
Pages 7 to 8. And I'm tending to assume she's probably right about it because she is a Scottish solicitor specialising in EU law. So I fancy that
you would think
she might know a bit about it.
Yes, absolutely so.
Not that I assume that anybody is always right.
I do. Yes, absolutely. But it's also, not only is she right on that, but it's also she's quoted strangely by the government. If we look at D34 in the bundle as well, which might be a wee bit difficult to read, but this is the back page of a pamphlet which is produced by the government.
Sorry, which 34?
D34.
D34.
D34 in the bundle.
Oh.
This is a booklet on the process of withdrawing from the European Union, which was presented to Parliament by the respondent in February 2016. And it says in that little box how these negotiations might affect UK citizens. UK citizens get a range of rights from our membership of the EU. If the UK were to leave the EU, all of these rights would have to be covered in a successor arrangement. If we left the EU without agreeing what would happen to these rights, it would be, at the least, bring them into serious question, creating difficulties for UK citizens who relied on them. Sorry, it's like a primary one reading class. A selection of these rights includes the right to live, work and own property in all 28 member states of the EU, the ability to retire to another EU country, the right to receive health care that is free at the point of use and paid for by the NHS using the European Health Insurance Card, the right to vote in local elections in other EU countries, mutual recognition of child custody decisions across the EU, the use of the European Small Claims Procedure to reclaim up to €2,000 from individuals in other EU countries, and the right to use public services in other EU countries. And of course, as I say, the right to be treated in the same way as citizens of the states in which they live, because they are not permitted to be discriminated against. So those are those rights, those are the very rights which the second appellate refers to in a witness statement, which the government accepts are being called into question by this referendum. And those are the rights which are relied upon. So, as I say, if one then goes back to the Melnichenko rationale given as to why it's justifiable to have a residence limitation on
47.
On elections in national legislatures, that doesn't apply when it comes to this one question, about continued EU membership, continued status of EU citizenship, and the appellants are being excluded from that. So, the second Melnichenko criterion, the impracticability and sometimes undesirability of parliamentary candidates presenting different electoral issues to citizens living abroad, that's not a problem. It's one issue, and we've all got the internet. We all know what the issues are. We can find out. The influence of resident citizens in the selection of candidates, that's got nothing to do with here. There's no candidates being selected. The correlation between one's right to vote in parliamentary elections and being directly affected by the body so elected, that is precisely the case here. They don't have the right to vote because it's been taken away from because of their 15-year free movement, but they are being directly affected. So if one looks at the Melnichenko criteria, you will in fact see that applying them to the appellants here, there is no rationale for their exclusion. The respondents say, well, you know, the legitimate aim, what you've got to do is look at the statute. Don't look at what government ministers might have inadvisedly said, reading from their briefs before Parliament. That's unconstitutional. Look at the statute. What does the statute tell us? That's where we get a legitimate aim from. Well, we look at the statute, and it's section 2. And what we see is this omnium gatherum of different franchises, and it's very difficult to work out why they're there when it comes to the particular question which this referendum is asking. Should British citizens retain or lose their EU citizenship? What we see is that all Commonwealth citizens resident in the UK, non-British Commonwealth citizens, get the right to vote. So an Australian on a work visa for 2 years has the right to vote on whether British citizens should retain or lose their EU citizenship.
It's basically the parliamentary franchise with a Gibraltar adjustment, isn't it?
Oh, and another rather important one.
Yes, absolutely. So that other important one, my lady, members of the House of Lords are also getting the vote. Isn't that nice?
Yes.
Yes.
Okay, well...
As they have in local elections.
As they have in local elections, yes.
Okay, well, in deference to others, let's assume that that is a matter of enormous constitutional importance. But all that we are concerned with is the parliamentary franchise with the addition of peers and residents of Gibraltar.
And Irish nationals residents.
Well, they have the parliamentary franchise too.
No, they don't, not for the Gibraltar franchise, not in Gibraltar.
No, but... Gibraltar residents, certainly, but Irish nationals have for many years had the right to vote, provided that they are resident in the United Kingdom.
But they've been they have specifically extended franchise to Irish residents resident in Gibraltar, exactly, who would not be covered by the parliamentary franchise. Now, what is the rationale for that?
So we are concerned with two minor adjustments. One concerns peers, and the other concerns residents of Gibraltar.
Well, it's a minor adjustment if you're not a peer. But clearly, every individual right to vote counts, and it's not good enough, frankly, to say it's a minor adjustment, because it's one person, one vote, and it's the only vote that one person gets, and the only vote which these appellants have is been taken from them, and that is not something minor. And to suggest otherwise is to downplay and disregard the democratic basis on which this constitution functions post-Nuremberg, rather than historically determined. So, what is the rationale for the exclusion of the appellants from this odd gathering of the franchise? There is none. No proper one. If anyone is concerned with the question, they are concerned with it. But people who are not concerned with the question, people who are not EU citizens, are added in. Some EU citizens are added in too. The Irish aren't Commonwealth citizens. They get the right to vote. And we're told, well, tradition. We've always done it that way. Well, that may be an explanation. It may be a hangover of the imperial past. But it's not a justification for disenfranchising individuals. And justification is what is required as a matter of determining the proportionality of this measure. And the only justification that we get, the only legitimate aim, is don't rock the boat. This is how we've always done it. And if you start changing it and actually thinking about it and saying, well, who are the people who are directly affected by this? Well, that might cause some problems within the politics of it all. And is political expediency then sufficient to allow for disenfranchisement? Not if you believe that the common law protects a constitutional democracy. It most certainly isn't. We have examples in other constitutional democracies. The German Constitutional Court has often enough said that there is a fundamental right to vote built in to the post-Nuremberg Grundgesetz, and that it is not only can it not be changed by the legislature, the constitutional right is beyond amendment.
Well, if we had a constitution in that sense, no doubt we would be directly considering the sort of illogicality which you've been submitting exists. But are you suggesting that as a matter of pure common law, we can do anything equivalent? I thought your case in this court was confined to EU law. Am I wrong about that?
Yes, you are wrong about that, my lord, in the sense that one is always enjoined by the court to don't think of the common law as an ossuary, source of inspiration. So I've been trying to be inspired by it in the sense that it is not. There's an article in about common law declarations of unconstitutionality, yes. Which looks at some of the case law of the Supreme Court of Canada, in particular the patriation decision in 1981 is referred to in that article usefully. In that decision, that was the decision of whether or not the Canadian government, was it under Pierre Trudeau then? Father of the more famous Justin.
So do we have this decision?
We don't. It was a very long decision. There's only so many trees I was willing to cut down for this, but I can certainly email it, my lady. But the decision itself was on the basis that there was a constitutional convention to the effect that the Canadian government should not go to the UK Parliament and ask for changes in the Canadian constitution without the consent of the provinces. And in this case, Pierre Trudeau was very keen on just pushing it forward, getting patriation done, and didn't get the consent of all the provinces. So there was a case taken by the provinces to the Supreme Court, and the Supreme Court said, as a matter of law, the Canadian Parliament is sovereign and supreme and can do what it likes. As a matter of constitutional convention, it's clearly breaching it. And therefore it made a declaration to the effect that they had acted unconstitutionally, although there was nothing that could stop it as a matter of law. So, what I say, so that's a useful and interesting precedent of common law constitutionality being used in relation to an excess, a breach of the Constitution, even within the context of a sovereign parliament, which is brought to the sovereign parliament's attention by the court. That is already done, of course, by Section 4 of the Human Rights Act, whereby if there is convention incompatibility, then a Section 4 declaration of incompatibility can be done. And that does not affect the enforceability of the statute. And I say it is no great leap. It is in fact a constitutional requirement of a constitutional court upholding the Constitution, because we do have a Constitution. We've got constitutional fundamentals. We must have some kind of Constitution. Constitutional principles, we're told in HS2. We do have a constitution. It may be inchoate, it may be incomplete, it may be multi-texted, it may be multi-textured, but there is a constitution and this
it hasn't got round, or has it, so far, in a context like this, to deciding that an Act of Parliament is inapplicable or pro tanto void without the aid of some of the human Rights Act, well, without the aid of construction under the Human Rights Act or without the aid of European Union law.
Well, and I'm not asking for a declaration that this is void or unlawful. What I am saying is it is within the powers of this court as it stands, as the Constitution now stands, to say that the disenfranchisement of these individuals has been done without proper reason, without a legitimate aim, and is therefore, given that we have a fundamental constitutional right, an unconstitutional deprivation. That is a powerful statement from one institution of government to another, from the institution of government, this court, which has the role of defending the Constitution. And we do have the precedent of the Supreme Court of Canada doing precisely that. Because what happens is that there may not be legal consequences, just as there aren't legal consequences with a Section 4 Declaration of Incompatibility, but there are potentially political consequences which follow on from that, as there should be as part of the institutional dialogue among the organs of state, that is, the legislature, the executive, and the judiciary. So, we are at the state in our constitutional awareness and understanding to allow this court to make a declaration of unconstitutionality, and that's it, as a matter of common law.
But actually, presumably, you're wanting this court to consider doing something more than that.
I am as well, but I'm saying you can at least do that because I've been told to be inspired by the common law and not treated as an ossuary. What one can also do in the 10 minutes I've got...
You've got
7. Let's not talk about it, it's losing me time. Is also to have a declaration. I'm only asking for a declaration in terms of incompatibility with EU law, following from this court's and your lordship's strictures in Chester.
Declaration, I mean, as a matter of legislation, in the context of the present referendum, all you are objecting to is the words in the 1985 Act falling within the period of 15 years, ending immediately before the relevant date. If that provision of the 85 Act had read that entry in the register was in force at any time before the relevant date, that would meet your bill, wouldn't it?
That would, but then the other side will then say, but oh, the sky is falling. You know, we don't have time. We've only got 2 weeks to fix everything. If you disapply EU law, if you disapply the Act under EU law, then it'll be unworkable.
It's Section 1, subsection 3C, which contains the 15-year period. If you just deleted the words falling within the period of 15 years, ending immediately, so it read was in force at any time before the relevant date, that would be...
That would be an effective remedy, absolutely. So
for the purposes of this 2015 Act, that's all they had to do.
But strangely enough, perhaps once bitten, twice shy, given my unsuccessful attempts in Chester to argue for any form of disapplication, I am also open to the idea that all this court need to do is declare matters as
what exactly? Have we got a framework, a draft of it somewhere?
In the statement of grounds of, I think we asked for a declaration.
Oh, dear. Well, you're in a hurry, don't worry, we'll find it. If that's what it is, we'll find it.
But there's no difference, is there, between a declaration that it's incompatible with EU law and it's being void? That's the automatic legal effect of its being
but then we're getting into those murky waters of what exactly is the relationship between the UK Constitution and the EU Constitution, which are
There's no doubt that under the 72 Act, if it's incompatible with EU law, it's ineffective.
Well, I'm glad your lordship's so clear on what EU law requires as a matter of constitution. Certainly that's what I thought post factum, but there seems to be a number of discussions, for example, in FAM, that sometimes falling on from the Bundesverfassungsgericht case law of the idea of ultra vires case law, ultra vires review of ECJ decisions.
Well, that's interpretation of Section 2.1. That's Lord Justice Lance's point. I noticed that FAM hadn't been cited when there was the discussion of Rotman. What was it referred to?
FAM was in the
It's
bundle.
in the bundles, is it? Yes.
It was referred to. I mean, it was referred to from the start because it was the basis for the idea of proportionality as a common law notion. So it was before the court. But the problem with, as I say, with Lord Justice Elias's suggestion is it came out the blue without either party arguing for it, and therefore, in a limited time, one couldn't refer to all the case law that would have gone on to it. But certainly, and the other side were the ones relying on Rotman. For once, I wasn't. So we're coming back to this. The question as to whether or not the declaration means absolute incompatibility. Well, that may be a matter for an argument on another day. But what one can say is that this court does, as it has done in Clyne-Terth, for example, given a declaration for the sake of clarification, even although it was admitted in that case that there was a breach of the relevant limits in EU law, a declaration that something was contrary to EU law, and subsequently, in Clyne-Terth number 2, a mandatory order was then pronounced. But at this stage, given the urgency of matters, given the political realities, a declaration of unconstitutionality as a matter of common law and of incompatibility with the free movement rights guaranteed to the appellants as a matter of EU law would suffice for my purposes. I wasn't sure whether I had.
Is that what you were planning to say?
Well, I was planning to go until 20 past, and I should have stopped.
Well, if you wish to go on till 20 past, you are very welcome so to do.
No, obliged. Yes, I mean.
Do you want? Have you said enough? It's up to you. But interference with citizenship or free movement, which is the second, I suppose, issue. Your case is reasonably clear. You say that we simply look at this in a somewhat abstract way, if I can put it like that. We don't ask whether if we found something which is a detriment to someone who's exercising their free movement rights, that's good enough to be an interference, even if he would still have exercised his free movement rights in the same way, or she would.
Yes, and that one could say that precisely because that's the facts of the case of Martins, and where the court is absolutely clear that there was no deterrent effect caused by the legislation, which was to do with eligibility to a student grant, when this individual went to take up study in the Dutch Antilles.
But isn't
Well,
the rationale?
no individual deterrent effect, but does the court require there to be a collective deterrent effect?
Well, I'm not sure that it does, but even if it did, because we've also got the case of De Cooper, which my learned friends are desperate to try and distinguish by saying it's an old case. It's a case from 2006, and it's a case from the Grand Chamber. That involved an individual. It might be worth looking at De Cooper, actually, because it seems to be being misunderstood. But the facts of that... Volume 1, tab 23. So,
what would you like to draw our attention?
what I'd like to draw attention is that this is a case involving an individual who was claiming unemployment benefit because he was over 55, didn't have to register for work. He moved to France from Belgium. That was then discovered. When it was discovered, his unemployment benefit was taken away from him. There was What the case does not do is say that that caused any kind of deterrent effect. Now, my learned friends are suggesting that was by some kind of oversight, but it wasn't, because the referring court specifically asked about whether deterring effect was a matter which had to be taken into account. If you see that at page 6981, the questions put by the Brussels Labour Court. Does the obligation of residence in the state competent toward an employment benefit satisfy the requirement of proportionality? Then the question, does the residence requirement not have the effect of discriminating between European citizens who are nationals of member states competent toward an employment licence allowance by affording entitlement to those who do not exercise the freedom of movement and residence of all European citizens, whilst denying it to those who do seek exercise, by the deterrent effect which that restriction entails? So we're asked about deterrent effect, and they say it doesn't matter. They say, paragraph 39, page 6987. It is established that national legislation such as this, which places a disadvantage certain of its nationals simply because they have exercised the freedom to move and reside in another member state, is a restriction on the freedoms conferred by Article 18, which is the free movement issue. That then has to be justified, and they go through the justification aspect. What they don't say is, but it only has to be justified if one can also say that generally it might deter other people seeking unemployment benefit in Belgium from going
Doesn't
to
it fall within the category of situations where it's obvious it would be some deterrent if you're going to lose your pre-retirement benefit?
I love the category where it's so obvious, because this is a case where it's so obvious, because what we have is you don't get the vote if you stay on in your country. You will get the vote back if you come back to the UK. You are therefore being deterred from continuing to live in Belgium or the United Kingdom, and are given an incentive to come back to the United Kingdom to get
I think
the
the
vote.
question put against you is, will anyone, or the Court of Appeals attitude, will anyone actually ever act on that?
Yes,
surely when you decide where to live, for almost everyone, if not everyone, the right to vote is not going to be decisive.
Well, I mean,
however important it is.
No, what happens there is that they're relying on Preston, where Preston rather oddly says, you look at the question of deterrent effect from the person thinking, gosh, should I move because in 15 years' time I might lose the right to vote? That is not what you look at. You look at these appellants and those others in situations like them. Is it liable to deter them, penalise them, give them some kind of incentive to move back to the United Kingdom? And the answer to that, yes, it is so obviously yes. And this idea that, oh, well, the learned friends say, well, there are these axiomatic clear cases like De Cooper where it's just obvious. But then this is a case where the evidence, there isn't evidence that people are moving back, and even if there were evidence, it wouldn't be relevant. And it's like, where do you get that from? Just look at this. This is a low issue. All that is being attempted here is to stop this court looking at the proportionality of this issue. The case law is in my favour. There is a deterrent effect on the appellants and others like them, the other, whatever it is. They don't even know how many people are being disenfranchised by this, but let's say 1 million. Just because 1 million is a nice number. But it's one of the numbers bandied around. They are all being penalised for having exercised the free movement for more than 15 years. They are being deterred from continuing so to exercise it. They're being offered an incentive to give up on it and come back to Blighty because you'll get your vote back, which means you can vote in the referendum and safeguard your rights and go back to Italy.
Well, we'd certainly know, wouldn't we, if any significant proportion of the million was coming back.
Well, according to the Daily Mail, yes, there are people in the Costa del Sol who are terribly worried about this, and pensioners are moving back in their summer droves. You know, I mean, but we're not here to bandy anecdote and assertion such as is made by the respondents as in, well, you know, of course people wouldn't be moving if they thought there was a possibility that the residents in Italy might be affected. What they'll do is stay. This isn't about whether you stay or whether you go. This is about what this legislation is liable to do, what its effect and intent is. And its effect and intent is to penalise, deter, and give an incentive to come back. That clearly cries out for justification as a matter of EU law. None has been forthcoming because there is none, because there is no legitimate aim. And the legitimate aim which is claimed of testing closeness of connection is not one which is vouched for by any materials and is referred to simply in court cases dealing with Parliament, elections to legislatures and not to referenda, and not to this referendum, and not to the exclusion of these appellants and others like them from this referendum.
That sounds like a ringing peroration, Mr. O'Neill.
I like to end on a bang.
Nicely timed, yes. Thank you very much indeed. Thank you. Mr. Brown?
No. Thank you.
Well, we will retire for a moment to consider what we might like to ask Mr. Eady to deal with. Well, Mr. Eady, in the first instance, we would like to hear from you on the fundamental question of whether there is any interference with free movement rights involved.
My lady, yes.
That's without prejudice to any other questions we might ask you, but we'll...
Shall I pass over Article 50 and...
Oh, pass over all of that for the time being.
Very well.
That's not to say that we don't think that it's important.
Just by way of introduction, and just before I turn to that subject, one of the members of the court asked where residence was dealt with, whether residence was dealt with in the legislative scheme. I'm afraid you don't have it in the bundle, but residence and how you work out whether someone is resident for this purpose is dealt with in Section 5 of the 1983 Act. Other bits, not Section 5, sadly, of the 1983 Act is behind tab 6. I also make it entirely clear that it is no part of the government's case to rely upon Nairn or the Arbroath Declaration of 1302, which my other friend relies upon, or any letters of Pope John the 22nd. None of that forms part of any positive case that we advance. My lady, my lords, interference, no restrictive effect. That is dealt with, as you will have seen, in the Court of Appeal's judgment between paragraphs 21 and 46, in the Divisional Court's judgment between paragraphs 27 and 40, and both of those courts followed the Court of Appeal and the Divisional Court in Preston, and the court in Preston is behind tab 16 of bundle 1. Not inviting you to turn it up now, but if you want the references where those courts dealt with this point about no restrictive effect, it's Divisional Court in Preston, Lord Justice Elias and Mr. Justice King, Lord Justice Elias in the Divisional Court in Preston at 38 to 39, and Mr. Justice King at paragraph 50, and then the Court of Appeal. Sorry, Mrs. Justice King at paragraph 50, and then the Court of Appeal in Preston between 74 and 81. And there was, as you will have noted, unanimity amongst them on this point, both as to the legal test to be applied and as to the application of that legal test in the context in Preston of the general election, in the context of our case of the referendum. The appellant's proposition, if I can start with that, they do not challenge the conclusion in Preston or in this Court of Appeal judgment that the 15-year rule has no dissuasive or deterrent effect on free movement. See for that record of that point, the Court of Appeal judgment at paragraph 80. Their case, therefore, rests on the proposition that it is sufficient to interfere with free movement rights for the individual to be able to point to some disadvantage or penalty, as they call it, which is related to the exercise of free movement rights, even if it has no dissuasive or deterrent effect. And we respectfully submit that that is simply incorrect. The elements which we submit are inherent in that legal test, in agreement with all the courts that have considered this issue, are threefold. Firstly, you need a disadvantage as a result of free movement. Secondly, and additionally, not alternatively, you need, as the Court of Appeal put it, adopting the wording of the Divisional Court at paragraph 38 in our case, you need a potential deterrent effect. So the potential deterrent effect of the measure, they said, is an integral element of the test to be applied. That test is set out in terms in many of the cases, and I'll give you some references in a moment. Sometimes, whether referred to expressly or not, the CJEU goes on in considering the facts to consider whether the measure is in fact liable to dissuade, and in doing so, the court is recognising that that element is an inherent part of the test. And in most of the cases, they specifically refer to it as additional to the existence of a disadvantage. So, as Lord Justice Mummery put it at paragraph 79 in the Court of Appeal in Preston, it is not every disadvantage of non-residence in the UK that is a restriction or deterrent to freedom of movement. The disadvantage must be, and I'm taking this from Lord Dyson's judgment in our case, but summarising Preston, at paragraph 25 of Lord Dyson's judgment, the disadvantage must be liable to dissuade or deter an individual from exercising his right to free movement. That's the second element, therefore. And thirdly, that integral part of the test is, we submit, reflected as the other side of the same coin in the consideration in the case law and the statement in the case law about there being effects which are, quote, too indirect or uncertain to amount to a restriction or interference with freedom of movement. And I put it as the other side of the same coin because the focus of that wording is on precisely the deterrent or dissuasive impact of the measure. And you'll recall that phraseology taken in particular, I think, from the Graf case. Graf is in bundle 2 at tab 31 if you want the full ECJ report. But the way it was put by Lord Justice Elias in the Divisional Court in Preston at paragraph 38, Lord Justice Mummery agreeing in the Court of Appeal at 74, was that the claimant had to show that the obstacle or measure could, and this is the wording, fairly be said to deter persons from exercising their rights. So those are the elements of the test, as we submit them to be, and we say they were correctly analysed in all of those courts as being necessary elements of the test. And I make two submissions as to why they were correct to treat those as necessary elements of the test. The first is that that is the standard reasoning of the CJEU on authority and specifically not departed from in Martins, which perhaps slightly surprisingly my learned friend has hardly referred to and not taken you to, it being the linchpin of his argument on this element. But my first submission is that standard reasoning of the court indicates that those elements of the test are cumulative, as it were, certainly as between 1 and 2. The second submission is going to be that that is unsurprising and obviously the correct approach in principle. Again, I'll give you the references in due course, but the rhetorical question that submission raises is, why would EU law be concerned with a national rule which had no deterrent or dissuasive effect on free movement at all?
Would EU law not be concerned by discrimination between treatment of people who had exercised rights of free movement?
Well, they might if you could build a case of discrimination, but a case of discrimination of that kind would itself have to have some impact, would be my submission on that analogue. But the way in which this line of case law has been analysed is not to treat them, as it were, as discriminatory in nature, but as to ask the threshold, the in limine question, if you will. Are you actually touching the right to free movement? Just by way of examples of cases in which that, I say it's standard reasoning, and one sees the standard reasoning, could you just take up bundle 2 of the authorities, if you would, very quickly? And I can take this at a spin, because the same essential point is going to be made in relation to all of these cases, all of which are in bundle 2. One starts with Morgan, bundle 2, tab 40. This is a case, it might be thought, whose principal entertainment value, at least, is to be found in the first paragraph of the Advocate General's opinion on page 9164. Might be thought to be a variant on the latest Sun headline of Analogue Judges at Sea in a Digital Age. But it produces at least quite an interesting quote on the qualities of judging from the South American jurist that you see recorded in footnote 2. But more relevantly for our purpose, the relevant paragraphs to which the Court of Appeal have referred, in our case, are paragraphs 25 and 26 in the Court's judgment. Page 9206 on the page numbers on the bottom. The Court of Appeal in our case refer to this case at paragraph 32, but you will see it's a pretty standard formulation in the case law. 25 refers to disadvantage, but sits, as it always does in this line of case law, alongside the references to deterrence. So you have disadvantage in 25 and you have deterrence in the third line of 26. And for good measure, in para 32, you'll see the references to the German argument about the impact being too uncertain or too insignificant. So you've got, if I can put it this way, all three elements of the test. And note paragraph 30 also, if you would.
But is that, it's very interesting, isn't it, reading this. One could read 26, the deterrent effect, as a reason for the rule, which is 25. Can you point us to some cases where it has been found that there is no interference because there has been no deterrent effect?
Let me just, may I check to see if there's one in that
question,
category?
Is it not?
It is, but you'll see that they
Mr.
do.
Cooper is obviously an example of a case where they didn't consider deterrent effect because, maybe because they thought it so obvious, as you would say, or maybe because they thought they didn't need to consider that, as Mr. O'Neill would say.
Yes, I think my answer in principle would be, one, that they split it out in terms of the analysis. And my lady, I suppose one could analyse 26 as being the justification for the rule in 25, but they do in lots of these cases then go on to consider the factual question of discouragement or deterrence. And so one sees that reflected in paragraph 30 of this case and in the argument that the German government mounted in paragraph 2. So if they're actually going on to examine on the facts whether there was a dissuasive effect, or, and I've cast them as 1, 2, 3, but you'll appreciate that 2 and 3 are flip sides of the same coin. So indirect and uncertain, too uncertain or too insignificant, those are aspects really of that the second deterrent or dissuasive effect point. And if they go on to consider those on the facts, the question is, why are they doing that if it's enough simply if it's a penalty? So I think that's the answer in principle. I'll check.
But if you can find an example.
Where it's directly there. But those are at least examples of cases where they've treated it as being relevant to go on to the second stage, which is rather against treating, as it were, para 26 as the mere justification for the single rule in para 25.
If it's uncertain or insignificant, then the inference from 32 is that they would have said it's irrelevant.
Yes. And that's why I say it's a separate limb, as it were, because you don't just point to a disadvantage. And indeed, keep going back to the point of principle, which appealed to all the courts below, why would EU law be concerned if it wasn't actually going to have any impact at all? It wasn't liable to have an impact on freedom of movement. And as I say, I accept, I make it absolutely clear, I think there was an exchange with Melania Fred, we accept that it isn't an ad hominem or an ad feminam thing. You don't have to look at the individual impact, but it's got to be liable to dissuade. Yes. So I'm told we haven't got a case exactly in my lady's category, but as I say, the key answer perhaps is that they go on in all of these cases to consider the issue of dissuasive effect and or whether it's too uncertain or too insignificant or too indirect. Even if there is a disadvantage, and they wouldn't be doing that unless it was an additional limb. And perhaps one can turn my lady's point round and ask the question, is there a case which says you can have an impact on free movement where they have positively concluded it would have no deterrent or dissuasive effect? And there is no case in that category of which we're aware. And that would demonstrate that you could have disadvantage without deterrence. But there is no such case. Indeed, on the contrary, they go on to consider that additional question. So that's Morgan. And without, I think, needing to trouble you unduly on in relation to the rest of the cases, if you simply flick through tolerably quickly in this file, Tas Hagen at tab 50. It's the same sort of structure, but in the judgment of the court on page 10.
This is a chamber decision, isn't it?
Yes, 10482. I won't take time on it, but just to show you the consistency of the mantra or the line of reasoning. They have indeed got paragraph 31, a disadvantage, citing De Kuyper, but they've also got paragraph 30. Can be deterred. So it's the same structure. Stewart, if you go to the previous tab, and you go in the judgment of the ECJ, page 35 of the law report, to paragraph 83,
Sorry, paragraph.
paragraph 83 in the judgment, page 35 of the law report. You have indeed got 83, it's my learned friend's case, treatment less favourable or disadvantage, but you've also got paragraphs 84 and 85. See second line of 84, could be deterred, and the reference to deterrence in the inter alia in the third line of paragraph 85. Still in the same bundle, sorry to go backwards, tab 27, LRIC. The relevant paragraphs here are 28 to 29. Same thing, 28, pre-penultimate line, constitutes a restriction. But 29, such a condition is likely to dissuade. And then look at the final sentence of 29. Restrictive effects cannot be regarded as too uncertain or too insignificant to constitute a restriction on freedom of movement. So the three elements of the test within those two paragraphs, 28 and 29, and this case and those paragraphs were relied upon by the Court of Appeal at paragraph 43 in our case. Tab 41 in the same bundle, Prince, and the relevant paragraphs in Prince are 27, disadvantage, 28, deterrence, and dissuasion in 32. So 27, 28, and 32. And it's perhaps worth noting two references to these paragraphs. First, the Court of Appeal in our case referred to this case and these paragraphs at paragraph 32 of its judgment. So that's CA 32 in our case. But interestingly, and it's one of the points that gives the lie to the idea that Martin's changed the law, changed the test in a significant way, 32 of Prince, with its references to likely to dissuade, as you see, is cited and referred to and relied upon by the CJEU at paragraph 31 of Martin's. Tab 30, the government of the French community case in the same bundle. The relevant paragraphs for this purpose are 45 to 47. And see also paragraph 51 at the bottom of 910 in the law report, where they approve the points made by Advocate General Sharpston, in her opinion, at 64 to 67. As she points out, the restrictive effects of the legislation in question in the main proceedings are not to be considered too indirect and too uncertain for it to be impossible to regard that legislation as constituting an obstacle. And then they distinguish on the facts graph. But it is perhaps just worth going back to Advocate General Sharpston's opinion. So if you flick back in the law report to page
883.
883, exactly so. And that, I think, is the direct answer to the question that was asked about individual impact or group impact. I think there was some discussion about that, but you see what she says in particular in paragraph 65. And you'll recall the phrase in the final sentence of that paragraph, in particular the reference to reasonably likely. That was the phrase which the Master of the Rolls, in our judgment, relied upon. He relies upon it in halfway through paragraph 45 in the Court of Appeal's judgment, in the judgment of Lord Dyson in our case. But it's that phrase picked up from para 65 of the Advocate General's opinion in this case that gives him the reasonably likely test. So that's a line of case law, all in the context of freedom of movement. And we've cited in our case before this court, as we did below, a series of other cases indicating that this reasoning, this combination of disadvantage plus the capacity to dissuade or deter, and uncertain effects that are too uncertain effectively being excluded. We've referred to cases in other contexts about the free movement of services, the free movement of capital, and so on, where exactly the same approach is applied. I give you one example only and don't invite you to turn it up, but it's in the same bundle if you want it. The Commission in Spain, bundle 2, tab 22, and the relevant paragraph for our purposes is 72. And we respectfully submit, in answer to my learned friend's arguments on this part of the case, that nothing in that standard reasoning is altered by the De Kuyper case. Indeed, as you will have seen from those paragraphs, De Kuyper is very frequently cited in the very paragraphs which establish that double or triple test. We'd also invite you to note, in relation to De Kuyper, that on the particular facts of it, as the question that my learned friend helpfully took you to, that was posed to the court, indicated, the court in question had in fact found that there was a deterrent effect. And so the question that was posed to the court proceeded upon that factual assumption. See the recitation of the question in paragraph 18 of the court's judgment in De Kuyper, which is bundle 1, tab 23. Secondly, and more significantly, we respectfully submit that the position is not altered by Martins. Martins is in bundle 2, tab 35, but the Court of Appeal dealt with it very fully, and the Divisional Court dealt with it very fully. Can I just give you those references where they specifically deal with Martins? Court of Appeal, in our case, 27 to 33, Divisional Court dealing with it equally fully, 35 to 38. And we respectfully submit that what my learned friend needs is an authority that demonstrates that the CJEU will find a restriction on freedom of movement where there is no dissuasion or deterrence, no practical effect on freedom of movement. That's why I think he went to Martins. That was the basis on which, one of the bases on which the argument was advanced below, because he says that was that case. Because the relevant law, as the courts below pointed out, the relevant law in Holland and the Netherlands only came in after the family had initially moved to Belgium. But we respectfully submit that for all the reasons given by the Divisional Court and the Court of Appeal here, that's not a good point. because after the relevant Dutch law imposing the restriction, 3 years residence out of the last 6, was introduced, it still had a continuing potential to affect freedom of movement in terms of coming back, even though they'd already moved to Belgium. But more importantly, both courts below squarely rejected, for reasons which we respectfully submit are unimpeachable, the suggestion that Martins represented, in effect, a fundamental change in the principled approach to be applied. And the change which it was said had been effected by my learned friend was to create mere disadvantage as sufficient, and therefore to leave out of account the elements of dissuasive or deterrent effect and or too uncertain, too remote. And for all the reasons that the court gives, or the courts below give, that is simply untenable, even untenable on the very face of the reasoning in Martins. And again, I'm not going to go back to Martins because we respectfully submit that its treatment in both of the courts below is entirely appropriate and proper. That's the answer on authority that we give. Mm-hmm. The answer in principle, again, can I take this shortly by taking you to the divisional court's judgment in our case. And the relevant paragraph for this purpose, simply because it's a very helpful and crisp exposition of the argument of principle upon which we positively rely, is in 38 sub 3 of the divisional court's judgment. Page A76, sorry, I've got my judgment separately, but if you want it in the bundles, it's A76, but it's para 38 sub 3. And I take you there because it pulls together the argument of principle, but also because that paragraph and that reasoning was accepted and applied if you go to the Court of Appeal's judgment, in the judgment of Lord Dyson. I do Mr. Coppola a disservice. He put the argument equally crisply, as is recorded in paragraph 41. So the court are effectively accepting and adopting 38.3 of the divisional court's judgment in 41 and 42.
Have you completed your submissions on the question asked?
I haven't quite. It slightly depends where you want me to go on, but I was going to go on very briefly to apply that reasoning, those principles, to our particular context. But again, the Court of Appeal and the Divisional Court did that tolerably fully. They particularly relied upon the reasoning in Preston, as you will have seen, which of course was to do with general elections. But they analysed very fully the reality.
Well, the divisional court, they both had to do that, haven't they?
They both had to do that.
Certainly both of them.
And so they've taken the Court of Appeal's reasoning and they've said that's unimpeachable. It's a question of the reality. It's not a question of the importance, therefore, of the impacts. Everyone can see the potentially important impacts on those who are resident abroad. The reality question is attached to the supplemental or consequential question, namely whether or not those would be likely, on any realistic basis, reasonably likely if you take Advocate General Sharpston, to have an effect on freedom of movement. And my learned friend is entirely wrong, with the greatest respect to him, to characterise Preston as having analysed that simply as being a prospective question at the beginning of the 15-year period. One only has to go back to the Court of Appeal's reasoning in Preston to see that they analysed it both at the beginning of the 15-year period, how realistic is it really that someone is going to not move at the beginning of the 15-year period, because 15 years later they might not be able to vote in a general election. Not realistic at all. But that wasn't terribly interesting in Preston. It wasn't terribly interesting in Preston because it was conceded by counsel for the claimant in that case that would be wholly unrealistic. So the entire argument in the Court of Appeal and Divisional Court in Preston surrounded the question as to whether or not it was realistic to suppose that later in the day someone might move back, be compelled or forced to move back in order to exercise their right to vote. And it was on that issue that the court focused, and it was on that issue that their reasoning was effectively that it was wholly unrealistic to suppose that anyone would operate or move in that way. And the position in relation to the EU referendum is that we have effectively got exactly the same rule, the same legislation, the very same legislation transposed with the wrinkles that you talked about earlier. And it might be thought, this isn't merely a structural or legislative point, it might be thought that if it's unrealistic to suppose that the inability to vote in a general election on the raft of issues that potentially affect both those who are resident here and those outside, it's unrealistic to suppose that the general election would not realistically impose that dissuasive or deterrent effect. All the more so we respectfully submit in relation to the single issue referendum of the kind we're dealing with here. But there is nothing whatever to suggest that any different answer should be given in relation to that question in the context of the referendum. Nothing to support the suggestion that either of these claimants was in fact in any way persuaded or would have been persuaded to take the second claimant to give up her responsible job in Belgium and move back here for the purpose of protecting the possibility of working in Brussels. It's just simply unrealistic. And that does complete my submissions on that issue.
Thank you very much, Mr. Reedy. We'd better hear what Mr. O'Neill has to say briefly in reply.
Very briefly, my lady. I'm sorry, I just don't understand the submission that was put, because a 95-year-old man has not upped sticks to get his vote back, but has said he seriously considered it. Therefore, that is not because he hasn't moved, then there isn't a restriction on his free movement. That's what it sums up. That's what it seems to be. In fact, what is said in the Flemish community case at paragraph 45, which is at tab 30, which the Court of Appeal referred to as if against me, is this: as a result, Articles 39 and 43 militate against any national measure which, even though applicable without discrimination on grounds of nationality, is capable of hindering or rendering less attractive the exercise by community nationals of fundamental freedoms guaranteed by the treaty. It's paragraph 45, tab 30.
Sorry, thank you.
And that's specifically referred to and relied upon by the Court of Appeal. Does the disenfranchisement from this referendum hinder or render less attractive the exercise by the appellants of their free movement rights? You bet it does. Can the first appellant do anything about it? No, he's too frail to come back. Is that not a hindrance, a penalty, and a deterrence for his continuing? Of course it is. This is a phony war. This is not a hurdle which has been failed to be overcome. This is a case in which the respondents have to man up and defend the proportionality of this case. Sorry to use a sexist term. But the issue is...
I'm not sure that there's a gender-neutral equivalent.
We'll work on that one. So it is quite clear that what we have here is a national measure which is capable of hindering or rendering less attractive the exercise of free movement rights. Martins, there is a fundamental misunderstanding, frankly, of the structure of EU law which is going on in these references to these cases, which are brought under Article 267 to the Court of Justice. These are not direct actions against a member state by the Commission declaring a law in general to be incompatible with EU law. That can happen. That's why we have direct actions. What Article 267 references do, however, is to say, are the rights of the individual before this court, the EU law rights being contravened by the application to that individual of the national measure in question? If it is, then the duty of the national authorities is to disapply the law in the particular case, not to have it declared void, erga omnes, against everyone and for all time. So, what is important in Martins is on the facts of the case, and they cannot be gainsaid or spun otherwise, this individual, Ms. Martins, was not deterred by the law in question, which restricted her access to grant funding because the law came in after her parents moved to Belgium. When she moved to university in the Dutch Antilles, she got the grant. What subsequently happened is that they withdrew the grant from her, and that's when she objected. And the matter then went to the Court of Justice, where it was held that she was entitled to the grant. She, as an individual, was entitled to the grant because it was penalising her for having moved as a 6-year-old with her family from the Netherlands to Belgium. Not because it deterred her from taking up her university place or anything of the sort. And it's not an answer to say, but it might have deterred other people. If and insofar as those other people were deterred, then doubtless the law could be disapplied in their case. And the previous case law, which is referred to in Martins by the court, are all instances in which, as a matter of fact, the court found that the individuals in question were deterred. That finding could not be made in the case of Martins because the facts were against her. But still, her free movement rights were said to be interfered with in a disproportionate manner by the fact that she was penalised for it. But in any event, as I say, this deterrence issue is a phony war because we are undoubtedly in a situation of being penalised for having exercised the free movement rights for more than 15 years and being offered an incentive to give up on one's free movement rights. This is not a scenario that was ever considered or looked at by the court in Preston, contrary to what my learned friend says, as was acknowledged in the quote below. The scenario that was considered in Preston was somebody who was nearing the 15-year mark abroad and then thinking, I'd really like to keep my right to vote, I better get back in terms of parliamentary elections. And that's what the court thought, well, that doesn't sound realistic in the real world. But that's not the situation we have here. It's all the appellants who have the one opportunity to get the vote for this referendum, which affects their rights directly. Of course, it's liable to affect the free movement.
Thank you. Thank you very much. Well, we'll retire again to see whether there's anything else we want to hear from Mr. Eady on. Thank you. We do not require any further argument, Mr. Eady. We should make it clear that the question is not whether this particular voting exclusion is justifiable as a proportionate means of pursuing a legitimate aim. The question is, firstly, whether European Union law applies at all, because only if it does so is there any possibility of attacking an Act of Parliament. And secondly, if so, whether there is interference with the right of free movement. Assuming, for the sake of argument, that European Union law does apply, we have decided that it is not arguable that there is an interference with the right of free movement for the reasons given by both the Divisional Court and the Court of Appeal in this case. We do have considerable sympathy for the situation in which the applicants find themselves, and we understand that this is something which concerns them deeply. But we cannot discern a legal basis for challenging this statute. Accordingly, the application for permission to appeal is refused, but unless there are any submissions to the contrary, we would grant the protective costs order which has been applied for.
I think the only thing that remains in relation to the PCO part of it is the amount. I think the position is that in the Court of Appeal below, I think it was 30,000 in the Divisional Court, reciprocal. In the Court of Appeal, it was 15.
And here 15 has been asked for.
15.
10. I think it was 10 that was asked for, Millie. Running low on our funds.
May have been 10, actually.
Let me just check.
May have been 10.
They were asking for 10, and if invited to make submissions, we would submit that the appropriate amount should be the same amount as in the Court of Appeal, namely 15. Yes. It's had to come on pretty quickly, but a lot of work has had to
15 is, paragraph 18 of your application says 15.
I think that was the one, because of the urgency, we just put in what was before the Court of Appeal.
I think there's a letter.
There's a letter that says 10, and I apologise for the confusion.
Does without indicating any more than just a figure, mention a reduced figure.
I'd be glad to say 15 on the merits anyway.
I would have said 15, but I'm not going to argue.
I think we'll do 10.
Obliged, Millie. Victory of sorts.
By a majority vote.
Reasons?
We are very, very grateful to everybody for the hard work that they've put into this hearing, inevitably at very short notice, and for the attractive way in which the submissions on both sides have been presented. Thank you all very much indeed.